Another issue which impedes the ability of IHL to protect civilian objects in a cyber operation is whether data qualifies as a civilian object. This question is significant as civilian objects are protected under the principle of distinction from being deliberately targeted during an armed conflict. There are two divergent views on this. The first argues that data is not an object and thus is not covered by the rules on targeting unless the cyber operation in question affects tangible components of cyber infrastructure. This is because the data is not visible or tangible. The second view, however, argues that data is an object and thus the cyber operation against it, resulting in its destruction, erasure, or alteration, must comply with the requirements of IHL. Proponents of this view argue that visibility or tangibility is not a requirement for something to be an object, and that the object and purpose of IHL necessitates an expansive interpretation. While the ICRC agrees that the question of civilian data constituting an object is not yet resolved, it does argue that the essential civilian data, such as medical data, biometric data, social security data, tax records, or election lists and records are essential to civilian life, and that IHL protection should extend to that data. Indeed, it does seem odd that information in paper form would be protected as an object, while the same civilian information stored digitally would not.